my name is Mikaela Meyer, and I'm currently a PhD student at Carnegie Mellon University. Today, I'm going to be presenting on our paper where we created a risk assessment instrument to predict whether an individual is at risk of receiving an especially lengthy sentence in the US federal legal system. In the criminal justice system today, risk assessment instruments are often used to predict the risk that a defendant poses to society. So for example, in the pretrial, parole, and probation settings, where the outcomes of interest for risk assessments are often whether an individual is going to commit new criminal activity, whether they're going to fail to appear to future court dates, or whether they're going to otherwise violate the terms of their parole or probation status, we can think of these outcomes as being framed as the risk that the defendant poses to society. However, we also see that the criminal justice system poses risks to the individuals that are within it. For example, the defendants often face the risk of being detained pre-trial, the risk of being wrongfully convicted, or the risk that they will receive a sentence that is especially lengthy given the legally relevant characteristics of their case. In particular, for this latter part, we notice within the United States federal legal system that sentencing disparities are well documented in the academic literature. These disparities occur based on an individual's race, gender, the district or circuit in which the case is being tried, so effectively the geographic region of the United States where the case is being tried, and the party of the president that appointed the judge that is overseeing the case. Sentencing disparities are problematic, considering the fact that someone who is being charged with the same crime as another individual might not receive the same sentence length, and it could be quite disproportionately off from each other. In order to try to combat these disparities and to try to potentially reduce these disparities in the long run, we were motivated to try to create this risk assessment instrument to predict whether someone is at risk of receiving an especially lengthy sentence in this US federal legal system. So our risk assessment instrument, we envision, could potentially be used later on down the line to reduce these sentencing disparities. To create our risk assessment instrument, we use a two-stage modeling approach. In our first model, what we want to do is define what an especially lengthy sentence is. And in our second model, we want to actually train our risk assessment instrument using this definition. Finally, we're able to evaluate our model and its predictions. So first of all, we wanted to define what an especially lengthy sentence was. And to do this, we think of an individual and their particular sentence, and we want to think about the legally relevant factors to their case. And then we want to think about individuals who have the same legally relevant characteristics and what sentences they received. We can think of this as thinking of this histogram that we're seeing on this slide. And so now we want to think about which of these bins or on which part of this histogram our individual sentence fits in. And we can think of setting a threshold as well, where say right here, there's a threshold such that any sentence that occurs in this blue bin is considered especially lengthy because it's longer than X% of sentences that individuals received who were similarly situated in terms of legally relevant factors. And this is roughly the definition that we're using going forward. So in order to be able to define whether a sentence was especially lengthy or not, we wanted to develop a model to predict what an individual sentence should be based on legally relevant factors. This model was based off of H-BART, or heteroscedastic Bayesian autoregressive trees. And in particular, we were interested in the heteroscedastic part of this model because we wanted to make sure that we were taking into account the heteroscedastic nature of our data. Specifically, we believed that sentences that were longer would have a higher variance than sentences that were shorter. And we wanted to take into account this non-constant variance in our modeling. The outcome for our model is the sentence length in months for an individual. And we use 56,430 sentences to both train and test our model. Based on the results of our model, so once we have these predictions, we wanted to flag the sentences that are greater than the upper bound of the individual's 1 minus alpha % one-sided predicted interval. So in our case, we chose alpha to be equal to 0.1. So that means that we were flagging sentences where that particular sentence was greater than 90% of sentences that were given to individuals who were similarly situated in terms of their legally relevant characteristics. Now on this slide, we're going to look at how our model did in terms of predicting especially lengthy sentences. So on the x-axis, we have the predicted sentence value in months, and on the y-axis, we have the actual sentence length in months. The bold points reflect sentences that we have flagged as especially lengthy, and the gray points reflect sentences that we didn't flag. So as we can see, we're not only flagging sentences that are at the top part of this graph that are actually lengthy in terms of the number of months that they are, but we're also flagging some sentences that are only a few months long or only, say, a year long. And in this particular case, what that means is that even though these sentences are relatively short in comparison to sentences that are over 400 months long, for this given case and for the legally relevant characteristics for this case, this was still considered an especially lengthy sentence. And we believe that the heteroscedastic modeling approach that we took allowed us to be able to flag sentences at this lower end. Next, now that we have these predictions of what someone is of whether someone received an especially lengthy sentence, we have these flags. We now want to be able to predict whether someone is at risk of receiving an especially lengthy sentence based on legally irrelevant factors. The legally irrelevant factors that we considered can be grouped into these three categories: the sociodemographic information about the defendant, such as their race or gender, sociodemographic about the judge, and also information about the timing, status, and location of the case, where, for example, the status could be related to whether or not the case was settled via a plea bargain. So our second model, our risk assessment instrument, was created using regularized logistic regression, which was trained via Lasso. The outcome for our model was 1, if the sentence was flagged as especially lengthy, and 0 otherwise. And for this model, we had 55,580 data points to split into training and test sets. So now we're going to look at the performance of our actual risk assessment instrument. And this plot is looking at the predicted risk categories for the test set, as well as the proportion of lengthy sentences for each of these risk categories. So we created these bins by looking at our predicted probabilities and splitting them into 5 different quantiles, which are these 5 risk categories. This y-axis is the proportion of lengthy sentences that empirically fall within each of these categories. So what percentage of people in the low predicted risk category actually received an especially lengthy sentence. And so based on this figure, what we see is an individual in the high risk category is empirically about 4 times as likely to receive an especially lengthy sentence than someone who is in the low risk category. Also, the base rate of especially lengthy sentences in the test set is 6% across all categories. So the proportion of especially lengthy sentences in the high risk category is about twice as high as the base rate across all categories. Next, we want to look at how our model performs compared to other criminal justice risk assessment instruments. What we have on the x-axis are the names of various criminal justice risk assessment instruments, and on the y-axis, we're showing their AUCs. So there are 2 takeaways from this graph. One is that if we're looking at our model and its performance, what we see is that it's classified as having a performance that is considered good based on the standards for criminal justice risk assessments. We also see that if we're comparing our model to other criminal justice risk assessment instruments, that our model performs comparatively to, say, the public safety assessment's new criminal activity outcome. Now we want to consider the technical limitations of our model. We want to acknowledge that there were some limitations, but we also want to point out on the next slide that these limitations also apply to currently used risk assessments. So first of all, we want to talk about data availability. So we were missing some context in terms of how the sentencing decision was made. For example, there might have been terms of the plea bargaining process that we are missing in our data set that could have better informed our predictions. And also, we're having issues with sampling bias. So the data set that we specifically used was called Just Fair, and it was created by a set of academics by merging in with the US Sentencing Commission data, information from Wikipedia, and a few other systems. So as these data sets were getting merged together, there were some sentences that were dropped from the data set. So therefore, the Just Fair data set, it might not necessarily be representative of all federal sentences that were given during that time. Furthermore, when we consider construct validity, there is no ground truth for an especially lengthy sentence. We had to make a subjective decision about where to set the threshold for an especially lengthy sentence. And finally, in terms of non-stationarity in the legal system, we just wanted to point out that, for example, when a judge is trying to make a sentencing decision, they have to make a calculation for how long a sentence should be based on sentencing guidelines. But these sentencing guidelines can change from year to year, which means that these calculations in terms of the range for a sentence length can also change from year to year. If significant changes are made, this could impact the validity of our model. However, again, the technical limitations that we find for our model also apply to other criminal justice risk assessment instruments. Again, for data availability, in the pretrial, probation, and parole settings, you're often missing context in the data that help the judge make their decision. In terms of sampling bias, in the pretrial setting, you're only observing outcomes for people who are actually released pretrial, which means you're missing outcomes for a bunch of people who still went through a pretrial decision process, but you're missing data about them. And so your model is experiencing the sampling bias problem. Also, in terms of construct validity, when we think about the outcomes that are being used in other criminal justice risk assessment instruments, they are often proxies for what we actually want to be measuring. So for example, rearrest is used as a proxy for new criminal activity, and all failures to appear are often treated as willful flight when, for example, someone might have failed to appear because they didn't have transportation to the court that day, and they weren't actually willfully fleeing. And finally, non-stationarity in the legal system also impacts these criminal justice risk assessment instruments. So as various crimes are being legalized or other policy changes are made that impact either the distribution of outcomes or the distribution of predictors, this could impact the validity of these risk assessment instruments. Oftentimes, the choices that are made by the developers of risk assessment instruments are left unexamined. And so to demonstrate the extent of the choices that are being made in development, we attempted to make our decisions when modeling in a way that models standard practices for developing risk assessments. And we just want to make sure that we're considering and being transparent about the values choices that were made in developing our model. So first of all, our team is interdisciplinary. We not only had people with technical backgrounds, but also people with legal expertise on our team. But again, the decisions that we made reflected some subjectivity in our decisions. Also, we needed to process the data. We needed to clean up instances where there were perhaps NA or missing values in the data set. And we also needed to choose which variables to include as legally relevant and legally irrelevant factors. This choice for legally relevant and legally irrelevant, we were able to make based off of the legal code and what considerations are made when judges are making sentencing decisions in terms of what is legal to consider and what is not, technically something that they should be considering. However, there are also other choices that we made in the data processing process that required some subjectivity. And so we just wanted to be transparent about that. For example, choosing the cut point for defining an especially lengthy sentence in our instrument is akin to choosing how to measure outcomes in other risk assessments, where you're choosing, say, whether to measure new criminal activity in the next 2 years or in the next 5 years. And finally, in terms of the modeling decisions that we made, not only did we make decisions about which kinds of models to use, but also how to evaluate these models. So for example, we used AUC as our metric of choice. And when we're using AUC, that means that we're effectively equally evaluating false positives and false negatives. However, this is really just what the entire criminal legal system is doing when they're using risk assessments, because they're also using this AUC metric. And so this AUC metric is frequently used in the criminal justice setting to evaluate these risk assessments, when in reality, perhaps that's not the best metric that they should be using. So in conclusion, our risk assessment instrument flips the script on criminal justice risk assessments by predicting the risk that the criminal justice system poses to the defendant. Our instrument performs comparably to other currently used criminal justice risk assessments. And we also find that the critiques and technical limitations of our instrument could also be applied to currently used risk assessment instruments. In terms of the future uses of our tool, we see a few of them, including advocating for reducing over-sentencing in federal courts, using the First Step Act, which enables defendants for the first time in history to directly file motions with the court to seek a sentence reduction where extraordinary and compelling circumstances warrant a reduction. So defendants could be using the outputs of our models to determine whether or not they are facing these extraordinary and compelling circumstances. And finally, we could use our models to identify appropriate cases for clemency, which is a power that allows the President of the United States to grant pardons to individuals convicted of federal crimes. Thank you for attending our presentation, and we look forward to answering any questions that you might have.